case is City of Akron versus David Stone. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims during your argument. Please refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Good morning, Your Honors. May it please the Court, Joseph Schell from Summit Legal Defenders on behalf of the appellant, David Stone. Your Honor, I'll reserve 2 minutes for rebuttal. This case is straightforward. The trial court can order forfeiture only if it has subject matter jurisdiction to do so, and it gets that one way and one way only, and that's if there is a forfeiture specification attached to the complaint. There was no such specification here, so the trial court had no authority to order forfeiture.
Was that raised at the forfeiture hearing?
It wasn't raised at the forfeiture hearing, Your Honor. It was raised in our objections to the magistrate's decisions, but it can be raised at any time. It can be raised for the first time here, which it isn't, but it doesn't need to be raised in front of the magistrate or the trial court at all.
What if property is retained for evidence?
So I think that's a different question than when the state is trying to get it to forfeit property. The statute that controls forfeiture, though, is clear that a specification is required. That's what 298104 says, is that property is not subject to forfeiture unless there's a specification. And the specification statute says that property may be forfeited only if that specification is included in the complaint.
So you're saying the only procedure for any evidence that was collected to be forfeited is if they add a forfeiture specification to the complaint?
That's correct. Yes. That's that's straight out of the specification statute. It's straight out of the criminal forfeiture statute.
Isn't that forfeiture specification? Isn't it to provide notice to a defendant?
That's part of the reason, yes, but the other reason is that it gives the trial court subject matter jurisdiction over that property to begin with.
So if in a plea agreement you agreed to a forfeiture hearing, isn't it clear that you have noticed that property may be subject to forfeiture, or that it could be contraband or instrumentalities?
So not on those latter parts of the question, Your Honor, no. You're certainly on notice that the state wants you to forfeit it or is pursuing forfeiture. But that's not all the forfeiture statutes are about. It's about notice, sure, but it's also about subject matter jurisdiction. This court and the trial court just doesn't have it without a specification.
Counsel, how is this subject matter jurisdiction? You can't. I'm sure you're not saying that the court doesn't have jurisdiction over forfeitures.
No, certainly not. It has jurisdiction over the forfeitures that. When there is a specification attached to the complaint. That's what this court said in Rucker, is what gives the trial court jurisdiction over it. That court said...
I'm sorry, go ahead.
I was just going to say, Your Honor, that what Rucker said in paragraph 9 is just that the criminal cases, nor the traffic case in that matter, gave the trial court subject matter jurisdiction over the forfeiture issue. Only a specification can do that, and there is no specification.
And the jurisdiction, though, jurisdiction is such a confusing thing. We've made it confusing over the years. It really shouldn't be, but we've made it confusing over the years. There's the subject matter jurisdiction of the court, says the kind of cases that can come in front of it. But there's also the type of jurisdiction that says the jurisdiction over that particular case, which is not subject to matter. It's kind of a hybrid. Why isn't this more the hybrid case? That obviously the court has subject matter jurisdiction. It's just a matter of you have to exercise it the right way in order to have jurisdiction over a particular case.
Yes, I think that I agree with what you said there at the end, that yes, it can have subject matter jurisdiction if there is a specification attached to the complaint. The reason that this isn't kind of a hybrid kind of case is because that's what the Ohio Supreme Court has said, and that's what this court said in Rucker, is that it's not the criminal case that gives the trial court subject matter jurisdiction over that property for the purposes of forfeiture. It's only a specification that does that. And without the specification, there is...
So let me give you some hypotheticals here. Let's say someone's charged with possessing pornography, child pornography, and the police person stabs someone with a knife in a murder case, is now that knife, is their knife from the kitchen, are they gonna be able to not, is that not gonna be able to be forfeited because there's no specification in the indictment?
So I think like seizing evidence and keeping it is different than actually forfeiting it, right?
So is this evidence in this case then?
Well-
Because we have a complaint where an officer did an affidavit saying that there was a threat of the use of a firearm, and indeed, there was a firearm in the vehicle of the person who allegedly made a threat about a firearm, having a firearm, or shooting somebody with a firearm. And then he pled no contest, admitting those facts in the complaint, which included an assertion about a firearm.
So I want to push back on the premise of your question a little bit there, because there is no sworn affidavit from an officer that says anything about a firearm.
There is, and I'll tell you why. Because there's a probable cause affidavit that's required when you file a municipal court charge, a misdemeanor charge. And in this case, the complaint and the affidavit double as one document, so that is an affidavit.
Okay, I mean, the field arrest in summons form is not sworn. There is an opportunity for that to be sworn and for it to be administered under oath, and it wasn't in this case. But I think regardless, what the forfeiture specification, or what the forfeiture statutes say, is that there has to be a specification attached to the complaint if you want to keep anything that is contraband, an instrumentality, or proceeds. If it's one of those three things, and you want to keep it for those reasons, before you get to proving whether it is one of those things, you must include a specification in the complaint. That is what every single court of appeals across the state has said that has addressed this issue, is that without that specification, there is no subject matter jurisdiction. That is the language that is used in most of those cases. Joanna's point earlier, yes, some of them also talk about notice, but it's not just about notice. It's about whether the trial court has authority to even consider forfeiture. And what this court said in Rucker is that it doesn't. Is that the criminal case doesn't give it jurisdiction, the traffic case in Rucker didn't give it jurisdiction over the vehicle in that case. The only way that there could be forfeiture of that vehicle is if there were a specification in the complaint, and there wasn't. That's the same thing here. There's no specification here. The city hasn't attempted to try, they haven't said like, oh, this could count constructively as a specification, right? There's just nothing here that gives the trial court the authority to order forfeiture. And it doesn't need to be raised to the trial court. Subject matter jurisdiction can't be waived. That's what the Supreme Court of Ohio has said. It also can't be created out of consent. So you can't agree to give the trial court subject matter jurisdiction over something that it doesn't have.
So when somebody agrees in a plea agreement that they're forfeiting their weapon, there was never subject matter jurisdiction in the first place to do that?
Yeah, I think that's right. And I think, we obviously don't need to get into that in this case because Mr. Stone did not agree to forfeit his weapon as part of the plea agreement. But I think that was right. And I think, I know some courts have said that, well, when you agree to plead, and I think they're viewing that as, well, the trial court's not really ordering forfeiture when you agree as part of a plea agreement, right? It's ordering you to abide by the terms of that contract of the plea agreement, I think is how they're getting around it. I don't know that any of those cases, though, explicitly say that. But, Your Honor, I think you're right. As a purely legal matter, I think that's right. The trial court can't order forfeiture over anything unless there is a specification in the complaint. And most of, I think half of the cases that the city cites for these plea agreement cases, there were forfeiture specifications to begin with. And when there aren't, the trial court doesn't have the authority to order it. I think that's the first level here, where the court could just stop there because there was no authority for the trial court to order forfeiture. Even if there were a specification, though, in order for it to be forfeited here for the misdemeanors, the charging statutes or charging ordinances have to specifically authorize forfeiture in order for it to be forfeited as an instrumentality, or the thing that's being forfeited has to be illegal per se, that is, it has to be contraband. Neither one of those apply here. Just if you look at, so Mr. Stone was originally charged with aggravated menacing, he was originally charged with assault, and then he pleaded no contest to disorderly conduct. None of those statutes nor ordinances say anything about specifically authorizing forfeiture. So it can't be forfeited as an instrumentality in this case for that reason alone. It can't be contraband either because I think I'll set aside the due process problems right now with the contraband with the contraband finding from the trial court below.
Did
But
anyone argue at the forfeiture hearing that it was contraband?
no, I think all the city said is that it was going to be an instrumentality. The trial court then said contraband, but I mean, the trial court's wrong for the reasons this court said in Quintile last year, right? It's that given the new concealed carry regime, it's not contraband to have a loaded vehicle in your car. That's simply not the case. So no, I think, right, you can set contraband aside. You don't need to, instrumentality you can set aside for the reason that there is nothing in any of these ordinances that specifically authorize forfeiture or statutes. So you can't get to whether this was instrumentality or any of those factors, get into the facts at all, because there's simply no legal basis for the trial court to order forfeiture here, absent the specification, or for any of the other reasons in the statute about instrumentality. So I think unless the court has any other questions, I'll reserve the remainder of my time for rebuttal. Thank you.
Good morning, and may it please the court, I'm Jacqueline Coleman on behalf of the city of Akron, which is the appellee in this matter, and the city is asking this court to affirm. Now, contrary to my colleagues' arguments here, we do actually have to get into the fact that Mr. Stone entered a plea agreement with the city. The plea agreement was to hold a hearing regarding the issue of whether his gun would be forfeited. And if I understand my opponent's argument, or Mr. Stone's argument in this, concerning the subject matter jurisdiction argument, his argument seems to be that the trial court lacked any subject matter jurisdiction whatsoever to accept Mr. Stone's agreement to hold a hearing. Now, what that means is if this court were to agree with that argument, here's what will logically have to happen. Because that agreement to hold a hearing regarding the fate of that firearm was an essential part of that plea agreement, if this court is to vacate, what happens is that means that Mr. Stone could not have knowingly, voluntarily, or intelligently agreed to a hearing, and could not have knowingly, voluntarily, and intelligently agreed to his plea of no contest. Then, what follows after that is that since his plea itself could not have been knowingly, voluntarily, and intelligently entered, his entire plea, including the state's agreement to dismiss the first-degree misdemeanor assault charge, or aggravated menacing charge, and to reduce his first-degree misdemeanor assault charge to a minor misdemeanor disorderly conduct charge under Akron's code, must itself be vacated. And what happens then is Mr. Stone goes to trial on the original charges. Whereupon, and I would remind the court that a specification is not the only way to achieve forfeiture. There's also in the statute the opportunity for the state, if it has not initially charged with a forfeiture specification, to include a bill of particulars, which puts the defendant on notice that the state may seek to have the property forfeited and what the property is. And that, under appellant's argument, would have also established subject matter jurisdiction. But that's something that if Mr. Stone were remanded for trial, the state would still have the opportunity to file. And it is a notice issue. And there are 3 ways to have evidence that is seized by the police returned to a defendant or not returned. There's the opportunity for forfeiture, which the defendant can challenge. The defendant can file under the same code chapter a request for return of the property, and it's unclear in the record which one this was supposed to be. There's also the opportunity to file a completely civil matter in terms of a replevin action. So this isn't the only way to deal with property that has been seized by police. And I would also remind the court that these statutes have gone into effect later. the current version that we have is a conglomeration of what used to happen in RICO cases, and we also have a separate traffic forfeiture provision. But the courts had power to forfeit a defendant's property long before any statutes were passed. But the overwhelming authority in this court and in other courts are that when a defendant has a plea agreement, a negotiated plea agreement, where one of the terms to which the defendant has negotiated is to either have an outright forfeiture of the property, regardless of whether there was any request by the city or by the state to forfeit the property. That, for instance, is the Hensley case in this court. No indication at all that the state requested forfeiture. But in cases like that, a defendant can agree to forfeit the property or to hold a hearing regarding whether forfeiture will occur, either as part of a guilty plea or even as a no contest plea. And that's been the case in this court. It's been the case with the 1st District, 5th District, 6th District, and 8th District. So and of course the agreement must be, as was in this case, either to the forfeiture or hearing, and must put the defendant on notice as to which property is going to be forfeited. In this case, it was Mr. Stone agreed to a hearing regarding whether the gun that was seized, loaded with a round in the chamber in the passenger seat of his car, was going to be forfeited.
But he didn't agree that it would be forfeited like a lot of defendants do. In this case is different because he agreed to a hearing.
Correct.
And I don't think we have any case law that has that circumstance.
Actually, there are some where there have been mentions, and those are the cases that I put in brief, that regard, the defendant agreed to maybe even a forfeiture. The trial court then had a hearing on it. Or the defendant agreed to the hearing, and then the trial court had the hearing, and the property was then determined to be forfeitable. So, the city in this case did comply with the terms of his plea agreement.
Do you agree that he has the right to appeal what happened at that hearing?
Yes.
Just like if you would set a sentencing hearing as part of a plea agreement for reduction, if you would do something, the state would do something and set a hearing on something, the defendant would still have a right to challenge conclusion.
That's correct, but the argument that the court lacked subject matter jurisdiction to even consider or even accept the plea that he had agreed to means that he could not have knowingly, voluntarily, and intelligently entered it. And that means that this court, if this court would agree with that argument, this court would then have to vacate the entire plea and remand it for trial. And unless there are any further questions by the court, the city of Akron would rest on its brief and ask this court to affirm.
Well, counsel, what makes this firearm an instrumentality or contraband subject to forfeiture, as the trial court found?
Well, regarding contraband specifically, contraband is defined as anything a person cannot legally possess, and that is involved in the offense. And still under my reading of 292316, a firearm that is loaded with a round in the chamber, sitting in the passenger seat within easy reach of either the driver or the passenger, is still improper handling of a firearm, which can even be a fourth-degree felony. So it is clearly illegal to possess in that manner. Then the fact that according to the information that was brought out in the record, that Mr. Stone had referred to that firearm when he was telling the victim, "I'm going to shoot you," that without that firearm, he could not have committed that offense.
So does the statement, "I'm going to shoot you," serve as the sole? Because it's my understanding firearm was in the car, there's an altercation going on in a parking lot,
That's correct.
he punched you, there. They are both out of their cars at this point, correct?
That's right.
Okay. And so the statement, "I'm going to shoot you," makes a loaded firearm an instrumentality that's in a car? Is that the case?
That's my argument, Your
Okay.
Honor.
I
And
mean,
I'm
it
sure
seems to be what the part of and parcel of what the judge, what the entry says.
that's
And
true.
moving on the objections, I just wanted to understand.
That's true.
The complaint actually says threaten someone with a firearm, threatening to kill them.
Correct.
So that sounds like the first, I mean, if you read that literally, they were threatening them with the firearm. Are those the facts that the defendant, when he pled no contest, were still the facts in the complaint?
Yes, because he admitted to the facts, and actually, the way the plea is worded, that he admitted that he was guilty, but still entered a no contest plea in order to avoid the civil liability that could flow from a guilty plea or a guilty finding that would result from a trial.
And when you plead no contest, don't you admit the facts in the complaint as well?
Yes, ma'am. And that's what happened here. So unless there are any further questions, which I would welcome, the state would rest on its brief, and for the city, I'm sorry, and urge you to affirm. Thank you very much.
Judge Hensel, I'll pick up where you left off here, asking these questions. Setting aside the subject matter jurisdiction stuff, setting aside the city's plea agreement argument, which it's raising for the first time here today, what makes it contraband? Nothing, right? This court said in Quintile last year that because of 2923-111, it is not illegal for someone to have a loaded firearm in their car. It's not contraband. That's in paragraph 23 of that decision.
But is that, I think I'm the author judge on that.
You are? Yes.
Isn't that alone, having if you are a person who's qualified to have a gun?
Sure.
And
There's-
it's not in itself illegal.
Sure, but there's no facts to establish here. There's no allegation that Mr. Stone isn't a qualified adult to have the gun. The first time this was ever raised at all
But don't
was...
we have to look at the facts of the underlying offense in order to determine if in that situation it is contraband? Like what if he wasn't a qualifying adult? Would it be contraband if he was under disability? If the person who had the gun in their car was under disability, for example?
I suppose there were some facts in the record to support that, and there aren't. There's nothing to suggest that he was not legally allowed to have that firearm in Ohio. The city didn't allege that. Nobody brought it up except for the trial court in response to our objection to the magistrate's decision. But I'm 100% confident there are no facts in the record to support that this was contraband. And as far as the question about the instrumentality, which is the only prong of 2980-102 that the city argued in the trial court, can't get to whether it's an instrumentality. Because in order to forfeit property as an instrumentality when you're charged with a misdemeanor, there has to be specific authorization in the statute, in the charging statute, that authorizes forfeiture. There's nothing like that in aggravated menacing, assault, or the disorderly conduct statute or ordinance. So it doesn't matter about what the other three factors under the instrumentality prong say. It doesn't matter what the facts say because the statutory language precludes this being forfeited as an instrumentality.
But if you plead guilty, if you amend a charge to disorderly conduct, but you don't amend the facts are the facts for the disorderly conduct, right?
The facts are the facts, but that doesn't change that in disorderly conduct ordinance, there's nothing that specifically authorizes forfeiture. And that's what you need under 2981-02A1CA2, is without that, you can't forfeit an instrumentality when we're talking about a misdemeanor as the underlying offense.
Could we take you said one of the ways that you can get something back from the state is to request it.
Sure.
Couldn't you say that agreeing to set a hearing is a request, and then there was a hearing set on that request?
No, I know that this was called sometimes a motion to return property. That Mr. Stone never filed a motion to return property, and under 298103, those only apply either pre-indictment or post-indictment, post-complaint, but before disposition. That's again what this court said in Trevette, is that once you plead, once there's a disposition, then you're solely in the forfeiture land, and it's up to the state. The state has the burden to prove forfeiture, that it's appropriate under the statutory provisions. That starts with the specification, and it continues with the plain language of the rest of the statutes. None of those requirements were met here, therefore there's no legal basis for the trial court to order forfeiture. We ask this court to reverse. Thank you, Your Honors.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and the opinions are posted on the Ohio Supreme Court website. Thank you again.
Thank you.